Welcome to the April roundup of Coffee with Compliance. My name is Colleen Patterson, and I'm the Vice President of Employer Services and Compliance at Savoy. I will be recapping all of the happenings in the legislative and regulatory landscape that has occurred over the last month and is impacting employee benefits. So, I've got a lot to go over for you today. Not that there's been a ton that's been happening, but there's been a lot of clarification that's been going on for the last month. So, the first topic that I have for you today has to do with employer plan guidance that was issued on the end of the COVID-19 emergency periods. So, on April 10th, President Biden signed the House Joint Resolution 7 into law. And essentially, it is ending the national state of emergency that was related to COVID-19 and was declared under the National Emergencies Act. Now, separately, the Biden administration, they announced that May 11th, 2023 will be the last day of the public health emergency, and that's the PHE declared by the Department of HHS. Now, back on April 1st, 2023, so there's been a lot that's been going on in the last couple of weeks around these emergencies. State governments started to resume conducting Medicaid eligibility determinations. And that's a routine process that was halted in the spring of 2020 due to COVID. So on March 29th, 2023, the Departments of Labor, HHS, and the Treasury, they issued FAQs that was explaining the impact that the end of these emergencies and the resumption of these Medicaid determinations will have on group health plans. So there's some key takeaways that I wanted to mention that was in the guidance. So the first one is the end of the outbreak period. Now, we've talked about this outbreak period for a long time, it seems like. And this is what was occurring during the COVID national emergency, where certain timeframes, for example, COBRA election and premium payments, HIPAA special enrollments, and the time frame to file claims and appeals were extended as a result of the outbreak period. And that was for 1 year or until 60 days after the end of the COVID national emergency, which we all know that this is what the outbreak period was called. The end of the COVID national emergency period is May 11th, 2023. So we're not that far from that date. And the outbreak period will end, and all otherwise applicable timeframes will begin applying again on July 10th, 2023. Now remember, it's 60 days after the end of the emergency. So since the emergency is ending May 11th, 2023, that means the outbreak period is ending July 10th, 2023. Now, the FAQs that I mentioned, they outline some general principles with respect to the end of the outbreak period and the reinstitution of previously existing timeframes. So specifically, they go over timeframes and mention that they're statutory minimums. So health plans are legally permitted to allow more time for participants to complete these actions because it's only minimum standards, so they can always do more. One of the other things that is mentioned in there for individuals who lose group health plan coverage before the outbreak period ends, their COBRA election notice is due no earlier than September 8th, 2023. And that's 60 days after July 10th. So July 10th is when the outbreak period ends. So if we're going back to applying regular timeframes, 60 days later from July 10th is September 8th, 2023. So this is how we're getting back to regular timeframes and applying these rules. Now, the other thing that was in the FAQs is that it did note that the departments released, the FAQs that the departments did release, they had multiple very detailed examples that were in the FAQs about how to calculate COBRA and HIPAA special enrollment timeframes. And it was actually really well done. So if you haven't seen that yet, or if you're starting to get questions and you're not real sure, and it would be helpful to see a visual to look at, the FAQs have some really good examples. So you definitely want to use that as a resource. Now, another thing that was mentioned in there was that any COBRA premiums that is due for coverage through July 2023 are due by August 24th, 2023, which is 45 days after July 10th. And again, July 10th, 2023 is the end of the outbreak period. So if we apply initial COBRA premium payment timeframes, 45 days later takes us to August 24th. So again, the FAQs go over this in more detail. Now, the last thing that I wanted to mention, and there was a lot in the FAQs, but I also wanted to mention the extension to the HIPAA special enrollment rights, that it applies to any triggering event that takes place during the outbreak period. So that means up until July 10th, 2023. So participants who experience triggering events through July 10th, 2023, they have until August 9th, 2023, which is 30 days after the end of the outbreak period, to request special enrollment in group health plans. Again, it's because we are applying the typical 30-day timeline at the end of the outbreak period. So if the outbreak period ends July 10th, the HIPAA special enrollment rights of that timeline applies again, which means it's 30 days later. That takes us to August 9th. And those examples are in the FAQs too. Now, the FAQs did also address Medicaid and CHIP special enrollment rights. And I think this is important to note because I know we've mentioned this before in our other monthly recaps, and it definitely begs re-mentioning again. So during the public health emergency, state Medicaid agencies have generally not terminated the enrollment of any Medicaid beneficiary who was enrolled on or after March 18th, 2020. Now, these programs are going to resume performing their standard enrollment practices, and that was taking effect April 1st, 2023. So that's including auditing eligibility for existing participants. So what this means is that the guidance specifically reminds employers that an individual is eligible for special enrollment in an employer-sponsored plan if they are otherwise eligible to enroll in the plan, or if the employee or the dependent was enrolled in Medicaid or CHIP coverage and their coverage was terminated as a result of loss of eligibility for that coverage. So it's the rules again are going back to the way that they were. So generally the applicable special enrollment period in these circumstances, it's usually 60 days from the loss of coverage. However, we have seen that some states are coming out and they're allowing more time, which is allowed, but at a minimum, they have 60 days. Now, the other thing that I wanted to touch on here that was in the FAQs was it did address COVID-19 diagnostic testing and preventative services. So after the public health emergency ends on May 11th, plans will no longer be required to provide COVID-19 diagnostic testing. That includes over-the-counter tests that have been typically at no charge. So plans will be permitted to impose cost-sharing requirements, prior authorization requirements, and any other medical management based on the date the claim was incurred. So, for example, the date a COVID-19 test was actually purchased. It's not the date the claim was processed. So, if the service was rendered during the public health emergency, it should not be subject to any cost sharing, prior authorization, or any other medical management requirements. Now, we know that carriers have started to address this. And this is just a reminder that if you haven't received communication yet, communication is going to be coming out because now the public emergency is ending. The way that these services have typically been covered up until this date is likely to change. Then the last thing that was in the FAQs that I thought was important just to call your attention to was the temporary guidance under the public health emergency. It allowed high deductible health plans to cover both COVID-19 diagnostic testing and treatment prior to the deductible without jeopardizing a plan's HSA compatibility. So the FAQs allow that the high deductible health plans may continue to cover both testing for and the treatment of COVID prior to the satisfaction of an applicable deductible pending future guidance on the topic. So again, as of right now, any future guidance will not require plans to make changes mid-year so that participants can remain eligible to make HSA contributions for the remainder of the plan year. So the FAQs go into this in more detail. So if that's something that you have been getting some client questions on, again, the FAQs are a great resource to get some answers. Now, the next topic that I have for you this month has to do with federal guidance that was issued on preventative care and the Braidwood decision. So this actually happened on March 30th, where U.S. District Court Judge O'Connor of the Northern District of Texas, he issued a final judgment, and that was the Braidwood decision. And that decision strikes down portions of the Affordable Care Act's preventative care coverage requirement. So you may have been hearing a little bit about this in the news. So the ACA requires the following preventative care services be provided to participants without cost sharing. And those are things like services with an A or B rating in the current recommendations of the U.S. Preventative Services Task Force. Also included preventative care and screenings for infants, children, adolescents, in comprehensive guidelines that was supported by the Health Resources and Services Administration. Another thing that is under the ACA preventative care services was preventative care and screenings for women's health. That was specified in the guidelines. And then also specified was immunizations that were recommended by the Advisory Committee on Immunization Practices. So what happened was Judge O'Connor's ruling states that the health plans cannot be required to cover services with an A or B rating recommended by one of these task force or agencies, with no cost share that were required after the passage of the ACA, which was March 23rd, 2010. So examples of these services would include things like colonoscopies, various cancer screenings, could also include chemotherapy for breast cancer and HIV PrEP care. So the ruling further provides that employers with religious objections to PrEP HIV medications cannot be required to cover those medications. So that's what this case is all about. Now, the agents or the departments came out, and the departments again is HHS, the DOL, and the IRS. They came out with FAQs, and the FAQs are labeled as ACA Part 59, and they were released on April 13th, 2023. Now, these FAQs provide initial guidance on how the Braidwood decision affects the requirement to cover preventative services without cost sharing under the ACA. Now, the FAQs confirm that this ruling has no impact on the ACA's preventative care requirements. So that's a really big thing to understand. Plans and issuers, they have to continue to cover the items and services outlined without cost sharing, consistent with the applicable regulations and guidance. So the specific services that were noted were not enjoined or prohibited by the Braidwood decision. Now, you may think that's kind of sounds a little bit conflicting, but additionally, the ruling does not affect the preventative services that health savings accounts compatible with high deductible health plans can cover without applying a deductible. Now, as I said, this may sound a little bit conflicting. So as you would imagine, this is likely to go through legal challenges, which we've already have seen is going to be happening because the Department of Justice has already appealed Judge O'Connor's ruling, and the Fifth Circuit Court of Appeals will hear the appeal. So this isn't over yet. So there's going to be more debate about this. And the Department of Justice has also asked a federal judge in Texas to stay or stop the Braidwood decision as the case continues to go through the courts. So we're going to continue to monitor this to see if anything is changing, but for right now, there's not a significant impact. Now, the next topic that I have for you this month is something else that we've been seeing, and it has to do with the Gag Clause Prohibition Compliance Attestation. Now, this is a lesser known requirement that goes all the way back to the Consolidated Appropriations Act of 2021. It feels like that was forever ago at this point. Now, the attestation is another employer plan sponsor requirement, and the first one is due December 31st, 2023. So that's probably why you haven't heard much about this previously, but you're starting to hear about it now. And I've been seeing articles about this in recent industry news. So I wanted to take a moment and just spend a couple of minutes on this topic. And if you're like me, the first thing that you must be wondering is, well, what are gag clauses and why is this popping up now? So it's popping up now because it was in the CAA of 21, but it didn't apply until December 2023. So gag clauses, they can be part of a provider agreement, and that they can restrict access to price and quality information. So gag clauses, they've been prohibited since December 27th, 2020, but they only gained prominence when federal guidance was issued, which was just this past year in February, and it was in the form of agency FAQs. Now, the FAQs make it clear that gag clauses cannot be included in a health plan contract, and that attestations must be filed by or on behalf of plans and indicate that these gag clauses are not in place. So you might find a gag clause in an agreement between a plan or a health insurance carrier, or even a healthcare provider, a network, a TPA, or any other service provider that offers access to network providers. So what has happened is that they can't be in there anymore. So employers or plan sponsors, they're subject to this requirement. And what they have to do is all employers that sponsor major medical plans are responsible for completing these attestations, including fully insured coverage, self-funded plans, and level funded plans. So essentially, no one is exempt from this requirement. So employers and plan sponsors, they should verify that their carrier or their TPA will be completing this requirement for them. And it's likely, and we anticipate that most of the carriers and third-party administrators will do this attestation, but the employer and plan sponsor has a responsibility to ensure that that is happening. Now, the verification should be in writing, so that means if the employer is using a carrier communication to show as proof of it being in writing that the carrier is doing it on their behalf, just make sure that your clients save that piece of information. Now, the last topic that I have for today has to do with RXDC reporting. I cannot believe that June 1st is right around the corner. And I feel like we talk about this every month because this is a pretty big deal to make sure that everything is done by this deadline. So as I mentioned, June 1st is right around the corner. So it is quickly approaching for RXDC reporting. And as we know, many carriers have recently sent out surveys to their clients to gather information that is required for these D1 and P2 data files. Now, this is information that includes premium and life years data. And we've talked a lot about this over the last couple of months. Now, carriers, they typically won't have this kind of information, hence the request from carriers to have employers provide this information to them. Now, we've had a lot of groups that have missed the deadline to submit information to their carrier. And when the client or our broker partners go back to the carrier and say, can I still submit the data? Can you give me a new link to use? Unfortunately, carriers are saying, no, we're sorry, we can't, because we have so much data that we have to put together that we have to stick to these strict timelines that we've laid out. So unfortunately, if you've missed getting us the required information, then you have to find another way to submit it. Now, this has prompted brokers and clients to ask us, can they submit the information directly to CMS? Well, at this point, because we're so close to June 1st, that is highly unlikely. And here's why. The CMS Health Insurance Oversight System, that's this thing called the HIOS system. It's not that easy to navigate, and there is no other alternative to use. Previously, email was an option. That is not an option this time around. So the other thing with this HIOS system is it's a multi-step registration process in order to set up an account. And you have to register the device that you're using. You also have to verify the users. You have to attest to the information and so on. So it's not all that simple. The process to get an HIOS account, it's still taking at a minimum 2 weeks before you hear anything back. So if you look at the calendar and compared to when the reporting is due, which is June 1st, there's not enough time to be able to go direct. So what is the option then if you have a client that has missed the deadline? So at this point, if they've missed the deadline to submit information, they're better off using a third party who is already set up with the ability to submit the data to CMS. And that's really the best bet at this point. But time is, of course, of the essence because many of these third parties are saying, we can do this for you, but we can only do it up until sometime between the 15th and the 20th of May, depending on the vendor that you're talking to. So if you need resources for vendors that can submit this information, reach out to your Savoy dedicated team, and we can certainly put you in contact with many vendors that will do this on behalf of the client. So that's going to wrap everything up for this month. As always, should you have any questions, please reach out to your dedicated Savoy team and continue to use all of the resources available on our website at savoyassociates.com. From all of us here at Savoy, stay healthy and safe, and thank you for joining us today.